Good morning.
My lady. My lady, my lords, I appear with Mr. Battu for the appellant, Ms. Katie Lee Webb-Harnden, and Mr. Mullen appears with Ms. Taylor Waller for the respondent, the London Borough of Waltham Forest. As your ladyship and your lordships will have seen, this is an appeal against the order of Recorder Midwinter King's Counsel dismissing the appellant's appeal brought under Section 204 of the Housing Act 1996 against the respondent's homelessness review decision of 29th April 2022, again made under the Housing Act 1996. And as your ladyships and your lordships perhaps know, but in any event will have spotted from the skeleton arguments, this is a second-tier appellate court for the purposes of this appeal, and therefore the court's primary concern is with the review decision, although I will, if I may, make some observations about the recorder's judgment in due course. There's a single ground of appeal, very unusually, not fleshed out by a number of others, a single ground of appeal, and as your ladyship and your lordship will have seen, that concerns the failure to properly discharge the public sector equality duty under Section 149 of the Equality Act by failing in particular to consider the discriminatory impact of moving the appellant and or single parents out of borough because they're impacted by the benefit cap. So it's a short point, benefit cap reduces their income, affects affordability if it's used as a proxy for affordability, and that adversely impacts on women and is a matter that ought to have been taken into account if the public sector equality duty was to be properly discharged. You'll have seen that the particular complaint concerns the respondent's decision to discharge its main duty, its housing duty, by the grant of an assured short-held tenancy in private sector accommodation in Walsall, very, very, very many miles away from the respondent district, well away from the appellant's home and her family home in Newham, support networks, and so on. Before I come to the facts, can I please just shortly take you to the statutory authorities? First of all, there's a joint bundle of authorities. You do not have, consistent with the practice direction, every authority referred to in the skeleton arguments in there, only those where they shed light on the arguments where there are matters in dispute. So starting, please, with the obligations of the respondent under the Housing Act. At page 1, you'll see section 193, the primary duty, and under 1, it applies where the local housing authority has satisfied the applicant is homeless and eligible for assistance, hasn't become homeless intentionally, and are satisfied that the applicant has a priority need. Needn't trouble you with C. And then subsection 2, unless the authority refer the application to another local housing authority, they shall secure that accommodation is available for occupation by the applicant. Primary duty to secure accommodation, the duty that's applicable in this case, turning over the page to page 2, you'll see subsection 7 double A, double capital A, and that allows the respondent or any local authority to discharge its duty by providing accommodation by way of a private rented sector offer. So it doesn't need to be local authority housing, can be private rented sector offer. And that's the offer that was made in the appellant's case. And then please, if I could take you to tab 5, page...
no 5, no tabs, so page, please.
Oh, perfect. Nor do I, so that's great. I thought you did. Page 14, forgive me, I've done it already. Page 14. Section 206 sheds further light on the obligations. 206, discharge of functions. Local housing authority may discharge their housing functions only in the following ways: by securing that suitable accommodation provided by them is available, by securing that he obtains suitable accommodation from some other person. So suitability is a key threshold. And then at page 15, section 208, so far as reasonably practicable, a local housing authority shall, in discharging their housing functions, secure that accommodation is available for the occupation of the applicant in their district. So primary obligation, that is before looking elsewhere, to secure accommodation in their district. And then please tab 19.
Page
19.
Page 19. I'm sorry, you said tab 19.
I'm sorry, I beg your pardon. Page 19, I do
Lovely.
beg your pardon.
Sorry about that.
Page 19, again, this deals with the question of suitability. This is the homelessness suitability of accommodation order. Matters to be taken into account in determining whether it would be or would have been reasonable for a person to continue to occupy accommodation, and in determining whether accommodation is suitable, issue here, for a person, there shall be taken into account whether or not the accommodation is affordable. Affordability is an issue here for that person, and in particular the following matters. And then it deals with financial resources, including, for example, social security benefits at Roman numeral 2. And then please, page 20, again on suitability, and this deals with location. So again, suitability, homelessness suitability of accommodation order 2012, except where Article 2A applies. Needn't trouble you with that, it concerns arrivals to the UK persons. Determining whether accommodation is suitable for a person, the local housing authority must take into account the location of the accommodation, including whether it's outside the district and so on. So there's a first threshold or obligation. Is it reasonably practicable to secure accommodation within the authority? And then a secondary obligation to take account of matters including, for example, distance. So a more particular obligation. And then, please, if I can take you to page 8. Perhaps take this very quickly. Page 8 is the right to request a review of a decision. So the decision that is the subject of this appeal is the review decision, and a person has the right to request a review. And we see section 2021 making that clear. And then at page 9, so the next page, subsection 1G, that right to request a review includes in respect of any decision of a local housing authority as to the suitability of accommodation offered by way of a private rented sector offer, as here. And then page 12, again I can take this shortly, section 204 gives the right of appeal to the county court, and that's where we were here. Section 204, if an applicant has requested a review, is dissatisfied and so on, he may appeal on any point of law. So that's the statutory scheme. And as to whether the matters in issue, when the matters in issue are to be determined, that is when suitability is to be considered. Is it at the date of the first offer? Is it at the date of the review? Is it at the date of the county court scrutiny? Or indeed, although we don't suggest that here, is it here? So can I ask you please to turn to page 263. And I'm using the bundle numbering, I should say. 263, Broderick. This was a case concerning suitability, an offer of accommodation, which was outside the respondent's district, a determination at a review level that the offer was suitable, an appeal to the county court, and then an appeal thereafter to the Court of Appeal. And if I can ask you please to look at page 277, at paragraph 41, and if I may just extract the point so your lordships, your ladyship and your lordship know where I'm going, it's our submission that it is possible, or indeed it may be required, we say under the PSED, for a housing authority to stop and say, well, we will hold on and see if suitable accommodation becomes available and provide some interim measure in the meantime. So if the respondent says, well, we simply didn't have any suitable accommodation at the time we made the offer or at the date of the review, we can answer, we say, with respect, well, you ought to have hung on. And if I can ask you please to look at paragraph 41 of page 277, paragraph 41, looking at where it's become unsuitable, but same point. However, it's possible to conceive an exceptional case in which accommodation might have become unsuitable as a result of a change in the availability of alternatives. As I understand him, Mr. Holbrook was inclined to accept that in the doubtless unlikely event of a glut of properties suddenly becoming available within a housing authority's district, it could be incumbent on the authority to make new offers to persons who were being housed outside the district. Moving on to the second of the three questions, whether the authority ought to have made an offer or otherwise performed its housing duty on a different date, the point I was introducing a moment ago, my lady and my lords, Lord Justice Lewison, as I've already said, as I've already mentioned, distinguished between suitability of accommodation and impugning an authority's decision to discharge its full housing duty at a particular time. Lord Justice Lewison went on to say that were an authority to be aware that a development would provide affordable housing was approaching completion, that may well be relevant to the question whether it should discharge its housing duty immediately or whether it should wait until the development is complete. I think, however, that it would be relatively rare for an authority's decision to make an offer on a particular date rather than to delay to be susceptible to successful challenge, especially as, and then over the page, the oft-reported shortage of housing that creates a backlog to these cases. 43, turning to the first question, whether the accommodation offers were suitable, seems to me forced to be answered by reference to the circumstances at a specific point, while the second and third questions may require examinations of changes over time. Those are the two matters I've just alluded to. Suitability is to be determined at a particular time where an applicant has accepted an offer and asked for a review. The focus will be on the position when the review decision is made.
Well, was this case concerned with physical characteristics to do with suitability, such as size, or was it to do with affordability?
It was to do with location and whether or not there were other properties, or she ought to have been housed in other properties nearer. So if we look at page 263 in the head note, we see in the third sentence, authority having no suitable properties in the borough made an offer of temporary accommodation 30 miles away, took issue with the suitability of that property, refused the offer, and then the reviewing officer upheld the decision as suitable, and the county court allowed her appeal on the basis that other properties between the date of the offer and the date of the refusal was a relevant consideration which wasn't taken into account. So it was the So looking back at 43, the court is there distinguishing at what point the relevant decision is made, so the suitability decision, or when suitability ought to be assessed. So says where an applicant has accepted an offer, as in this case, and asked for review, the focus will be on the position when the review decision is made. That, however, will not be so where an applicant has refused an offer and the housing authority has its duties come to an end. So we're concerned with the former case. The issue is at the date of the review decision, and I am inviting this court to have regard to the fact that in this case, the court recognised that in determining suitability, the question whether accommodation might soon become available could be a relevant factor. And we say a fortiori where the PSED is engaged. So that was the reason for taking you to that case, my lady and my lords. And then if I can take you, please, to Ali Heat, which is at page 204. Again, to deal with the question whether or not one can hang on. This was if one looks at the facts of the case, with two cases in fact, page 206, again, page 206, page, so 206, paragraphs H17, and then in the case of Alib Keat, and then in the case of Adams at H23. Again, these were cases where the applicants were housed outside the borough, and the question arose whether or not that was appropriate, and whether or not further efforts ought to have been made to secure accommodation within the borough or within the district. If I can ask you please to look at page 225.
You just hold a moment, sir, and should there have been more efforts to find places within the borough?
Yes. And there were issues about timing of the offer, so a similar point to that which I was just making. So I was inviting you please to look at page 225 and paragraph 74. This is the applicant's arguments put on behalf of the applicant. He drew, that is the applicant's counsel, support for this submission, that is reasonable time frame, and so on. Drew support from the decision of Recorder Wilson, Queen's Counsel in the Central London County Court. Recorder said, in the context of location, the concept of suitability can be seen not to be an absolute one, but a relative one, depending on availability or non-availability of something closer. This relative suitability must, as I see it, have a further important consequence. As soon as one allows the test of suitability to include the relative element, it seems to me that in cases of far away placements, the test should also include some consideration of the time scale within which more suitable accommodation might be found. And this is Lord Justice Lewison. In this passage, the Recorder was addressing the suitability of accommodation, which is a different question from impugning an authority's decision to discharge its full housing duty at a particular time. I would accept in some cases considerations of time scale are relevant considerations. And just to be completely fair, because this is a point made by the respondent, if one turns over the page, the second substantive sentence at page 243, if a housing authority decides to discharge its full housing duty by making a private rented sector offer, I do not consider it must wait in the Macauberish hope that something will turn up. It follows that, in my judgment, Westminster discharged its duty. So, short point is, may consider what comes up in determining suitability or what might come up, but it's not a general obligation to sit around and wait and see if something better might turn up. As to the benefits regime, the easiest way to describe what is a complex regime is by taking you to one of the recent cases in which this was explored, and this is at page 37, and that is the case of DA. Supreme Court case. This was the second of three, I think, so far, cases on the benefit cap, and it concerned a change to the benefit cap, reducing the level of it, so increasing, it was said, the disadvantage to certain cohorts of women. The benefit cap, as your ladyship and your lordship will probably know, fixes a maximum ceiling on benefits irrespective of circumstances that might mean ordinarily, or but for the cap, a further sum would be awarded.
So just your client is on universal credit, so there's a limit on the amount of the housing benefit that you can receive as an element of universal credit. Is that it?
Yeah, there's a standard element,
yeah,
and there's a housing element,
yeah.
And the together they're capped, and the as I'll come to in a moment, the cap doesn't apply to temporary accommodation for reasons I'll come to, but for present purposes, both elements are capped. And if I can ask you please to look at page 42. I won't read it out if unless your ladyship and your lordships want me to, and I suspect you won't, but it summarises the history of the benefit cap, where it derives from, paragraph 2, Welfare Reform Act, amendments made thereafter, describes the SG case, which was the first benefit cap case, and pausing there, you'll see at paragraph 3 of DA, paragraph 3 at page 42, it notes that in SG and the original benefit cap, by a majority of 3 to 2, dismissed an appeal by 3 lone mothers and 3 of their children against a decision that provisions relating to the original cap did not discriminate against women in the enjoyment of their possession of welfare benefits and so were not unlawful. And as I'll come back to again in one moment, that wasn't because there was not disproportionate impact. There was disproportionate impact on women, because women are more likely to be sole parents, and sole parents are disproportionately affected by the benefit cap. But the Supreme Court found that it was justified.
So there was no discrimination.
There was no discrimination, but there was disproportionate impact. And, my lords, as I will come to in a moment, the fact that there was no discrimination in relation to the general benefit cap, that does not mean in my submission that it will be lawful if used as a proxy for other decisions where there's disproportionate impact. And in any event, it will always be a matter that falls to be considered under the PSED, because even absent the need to have due regard to the need to eliminate discrimination, there is a positive obligation to have due. Explain, it's not a positive obligation, forgive me. It's a due regard obligation to advance equality. So it has a different element to it. If you have women disproportionately impacted, by an affordability criterion, benefit cap, that has disproportionate impact, so they're disproportionately disadvantaged. In asking oneself, is the PSED triggered, as I'll come to, the answer must be yes, because there is disadvantage. But perhaps I'll pick that point up when I deal with the PSED, because perhaps I'll hopefully articulate it a little better than I just have. So sets out the history, notes SG. There was disproportionate impact in SG, but it was justified, so there was no discrimination. And then if I can ask you please to look at page 46 and 47. So 46 is paragraph 22. The impact of the revised cap has been broadly as follows. As of August 2017, the benefits of 68,000 households have been reduced by reference to the revised cap. 52,000 of those households would not have suffered a reduction by reference to the original cap. Of the 68,000 households who suffered the revised cap, 49,000, 72% were lone parent households. Since 90% of lone parents are women, 44,000 of the households which suffered the revised cap were lone female parent households. So, and then a couple of sentences down, the cap has therefore had a major impact on the former group, of which the latter are a significant subgroup, those with children under 5 and under 2, respectively. So, just as with SG, and perhaps unsurprisingly, the benefit cap most adversely impacts on women because they are most likely to be the carers of children, and single parents in particular, single women parents in particular, because frankly they're more likely to be poor because they're at home looking after children by themselves. And then if I can please take you to paragraph 48 and 49, because this is a matter I will pick up towards the end of my submissions, so I don't have to come back to it. Paragraph 30, the court deals with the government's defence of the cap, and in particular its reliance on discretionary housing payments. So at paragraph 30, the government's defence of its application of the revised cap to lone parents in the circumstances identified in these appeals relates in significant part to the provision for the possible making to them of a discretionary housing payment. Provision for discretionary housing payments is made in the 2000 Act and regulations. A power to make a discretionary housing payment is conferred on local authorities, and as the title implies, it must relate to housing costs. So when a cap requires a local authority to reduce housing benefit below or further below the level of the recipient's rent, pausing there because of the benefit cap, there is a facility for it to make a DHP to cover the balance. Central government provides local authorities with an annual fund out of which DHPs can be made, and a guidance manual, broad discretion, and DHPs are intended to cover many more situations of hardship than those created by the cap, and so on.
Mainly intended to alleviate temporary hardship.
Yes. I didn't mean to overlook that. And particularly mindful, my lord, that if we're looking at temporary accommodation, then one isn't so. To manage the transition for various, intended to alleviate temporary hardship, and for those subject to the cap are intended, in the words of the IA, to manage the transition for various customers while they make the necessary changes to adapt to the cap. Manual, however, now includes within a list of possible recipients a household which contains a child under 2 years of age, while childcare is a barrier to getting work. Our client has a child under 2 years. So, DHP, we say, was a relevant consideration in determining whether or not justification was made out. I'll come back to that. At paragraph, page 52, forgive me, page 52 to 53. At paragraph 42 onwards, Lord Wilson, who gives the majority judgment, the main judgment, forgive me, deals with the way in which the discrimination complaint is formulated. I needn't trouble you with that because ultimately the case turned on justification. So if one looks at page 55, at paragraph 55, explores the test for justification, and then at page 64, finishing off, page 64, conclusions. I'm also driven to conclude that the government's decision to treat the appellant cohorts similarly to all others subjected to the revised cap was not manifestly without reasonable foundation, not manifestly without reasonable foundation being the justification threshold in this context. In this regard, for reasons which I will not rehearse, the DA cohorts have a stronger case than have the DS cohorts. That's because of the age of the children. But again, by a narrow margin, even the stronger case fails. The appellants have not entered into any substantial challenge to the government's belief that there are better long-term outcomes for children who live in households in which an adult works. Belief may not represent the surest foundation for the similarity of treatment in relation to the cap, but it is a reasonable foundation, in particular when accompanied by the provision for DHPs, which are intended on a bespoke basis to address and which on the evidence are just about adequate in addressing particular hardship that similarity of treatment may cause. That is in the application of the benefit cap. As to, that's all I needed to take you to on that case, my lady, my lords. As to the impact of the benefit cap in temporary accommodation, the position is very different. I'll come to what we say about this when I look at the submissions in advance of the review decision, but I don't think it's disputed that where temporary accommodation is provided, whether it's by means of a private sector rented offer or otherwise, the rent element of universal credit, or the housing element, isn't paid. Instead, it's dealt with by housing benefit provided by the local authority, and the government meets that liability, that responsibility. The easiest way to come to it is when I look at the submissions. I don't think that's in dispute.
At some stage, not now to take you out of your course, it would be very, very helpful if you explain to me in the context of section 192 precisely what you mean by temporary accommodation, because the duty is to secure that accommodation is available. Temporary is sometimes used to mean it'll do for the moment whilst you look for something that is more suitable. So if it's urgent, it might be B&B. If it's more medium, it might be a flat, but longer term, it might be something else. So it'll be very helpful to me if at a decisional stage in your submissions, you explain what you mean by temporary accommodation linking into the Housing Act.
Just if I can touch it now and come back to it in due course, but just so your lordship has the point. Temporary accommodation may be provided in performance of the duty as opposed to discharge. So in other words, one might be provided with temporary accommodation while the duty is being discharged, and ultimately provided with permanent accommodation and the duty discharged. If I can ask you please now to look at the public sector equality duty, mindful I know that you'll be...
So the duty is to secure accommodation is available. One way of doing that is by providing short-term accommodation. accommodation. That will not ultimately discharge the duty, but it may be sufficient for it to be suitable for the moment, but the duty remains. But when you provide a permanent accommodation, then the duty will be discharged. Is that it?
Yes.
It's a method of performing, or
Precisely.
for a temporary period.
Precisely. And there is a policy on it, which I'll take to shortly in due course. So if I can ask you please to look at the public sector equality duty, which is at page 17 of the authorities bundle. Page 17, a public authority must, in the exercise of its functions, have due regard to the need to eliminate discrimination, harassment and victimisation, and any other conduct that is prohibited by or under this Act, and advance equality of opportunity between persons who share a relevant protected characteristics and persons who do not share it. Neat and trouble you with C. So there is elimination of discrimination and advancement of equality of opportunity, two distinct limbs. And then at subsection 3, having regard to the need to advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it, involves having due regard to the need to remove or minimise disadvantages suffered by persons who share a relevant protected characteristic that are connected to that characteristic, and take steps to meet the needs of persons who share a relevant protected characteristic that are different from the needs of those who do not share it. So there is a requirement to have due regard to the need to ameliorate or mitigate disadvantage. As to discrimination, page 16, that includes indirect discrimination. Page 16, indirect discrimination, a person discriminates against another if he applies to the complainant a provision, criterion or practice which is discriminatory in relation to a relevant protected characteristic of the complainant. For the purposes of subsection 1, a provision, criterion or practice is discriminatory in relation to a relevant protected characteristic of B's if A applies or would apply to it to persons with whom B does not share the characteristic, that is, applies to everybody. It puts or would put persons with whom B shares the characteristic at a particular disadvantage when compared with persons who do not share it. It puts or would put the complainant at that disadvantage, and A cannot show it to be a proportionate means of achieving a legitimate aim. So subsection 2, we can see that it's essentially a neutral provision, criterion or practice that's the subject of section 19, applies to everybody, irrespective of their protected characteristics. And it puts, though, in our case, women at a particular disadvantage when compared to men. In our case, that is because women are more likely to be subject to the benefit cap. They're more likely to be poor. The applicant here, the local authority, cannot show it to be a proportionate means of achieving a legitimate aim.
Sorry to interrupt. When you say it puts and cannot show it to be proportionate, you're not challenging the benefit cap, you're presumably challenging the housing policy.
Precisely.
Yeah.
So it's the policy that the respondent applies in deciding upon suitability and affordability. That is, if you're on the benefit cap, you're not going to be able to afford accommodation in London. And we say that...
Hold on, sorry.
Sorry, I beg your pardon.
So the policy that the respondent is in deciding on suitability or allocation, you said, I think?
Affordability.
Affordability. If on the cap, or if on the benefits cap, you will not get accommodation in London.
Yeah. And we say that's the end of it.
Yeah.
And just to pick up on a point so I don't have to come back to it, the provision, criterion or practice in issue doesn't itself, in and of itself, need to be unlawful. It's a neutral provision that has disproportionate impact. So a perfectly lawful condition, let's say you need 3 A levels in science subjects to get into an arts degree, it's likely to disadvantage girls. Nothing wrong, nothing unlawful about the condition, but it may disproportionately impact on a protected class. An absent justification may amount to indirect discrimination. So that's the PSED and the concept of indirect discrimination, which is premised on disproportionate impact. This isn't in dispute, so if I may just alert you to it. The jurisdiction, the county court's jurisdiction under section 204 of the Housing Act, and that was the basis for consideration below, does not extend to hearing freestanding discrimination claims. So one can bring a claim in reliance upon the failure to comply with the PSED, plenty of authority on that, but cannot bring a freestanding Equality Act, private law, effectively, claim. As to how a public authority should approach the public sector equality duty, the summary that is most frequently relied upon now, including by the Supreme Court, is in bracking, and that is at page 112 of your bundle. You'll have seen from our skeleton argument that we make the observation that this was referred to by the Supreme Court as good enough, essentially, a good enough summary in HOTAC. HOTAC's not in your bundle, but if it's helpful, I can hand it up. But bracking is now the authority that's most commonly relied upon. It concerns the decision to close the Independent Living Fund, but got nothing to do with us so far as the facts are concerned. At page 120, at paragraph 26, the approach is summarised by a collecting together of all the relevant authorities at that point, all the matters that have been dealt with by the relevant authorities. Paragraph 26, as Lady Justin Arden stated in Elias, equality duties are an integral and important part of the mechanisms for ensuring the fulfilment of the aims of anti-discrimination legislation. They're not by the by, they're central. An important evidential element in the demonstration of the discharge of the duty is the recording of the steps taken by the decision maker in seeking to meet the statutory requirements. Relevant duty is on the decision maker personally. What matters is what he or she took into account. And then 4, the decision maker must assess the risk and extent of any adverse impact and the ways in which such risk may be eliminated before the adoption of a proposed policy, in our case a decision. So just if I may emphasise that, must assess the risk and extent of adverse impact and the ways in such risk may be eliminated. And then at 5, these and other points were reviewed by Lord Justice Akins in Brown as follows: the public authority decision maker must be aware of the duty to have due regard to the relevant matters. There's a tweak to that in one moment I'll come to. The duty must be fulfilled before and at the time when a particular policy is being considered, must be exercised in substance, with rigour and with an open mind, not a tick box exercise, non-delegable, continuing one, and it's good practice to keep a record. 6, and importantly in my submission, general regard to issues of equality is not the same as having specific regard by way of conscious approach to the statutory criteria. And then at 8, I can take you to 7, this concerns the extent of the duty. Finally, it's helpful to recall passages from the judgment of Lord Justice Alliance in Hurley and Moore. Roman numeral 1, contrary to a submission advanced by Ms Mountfield, I do not accept that this means that it's for the court to determine whether appropriate weight has been given to the duty, provided the court's satisfied that there's been rigorous consideration. So there's a proper appreciation of the potential impact of the decision on equality, objectives and desirability of promoting them. So the duty is a due regard duty. It's not for this court to determine whether adequate weight and so on was given to the matters falling within the scope of the duty. And then next paragraph, within this quoted section, concept of due regard requires the court to ensure there's been a proper conscientious focus on the statutory criteria, but if that's done, the court cannot interfere, and so on. Those are all the matters I need to take you to there. So just, if I may, drawing out the key points, it is an important duty. It's not something that one just adds on the end and tick boxes. It is important. There must be evidence that it's been discharged. I'll come to what needs to be discharged. That is, whether or not a local authority needs to know what it's doing. There must be a risk assessment. What's the extent of any adverse impact and what might be done to eliminate, or my submission, ameliorate it. And general regard to equality is not good enough. There must be a focus on the particular limbs set out under section 149. As to the approach of the court in looking at whether a local authority has complied, take you please to another authority, page 128, Hack. This was a disabled person allocated hostel accommodation and challenged the decision that it was suitable in reliance on the public sector equality duty. And then at paragraph 3, just to make good the point I made a moment ago about the PSED being available in an appeal of this sort, paragraph 3, common ground and plainly correct that the PSED is engaged in the course of any decision making about the suitability of accommodation. And then at page 139, there's a summary of all the cases, and they include the cases, include bracking. We see that referred to at paragraph 35, and at paragraph 37, there's the analysis and a point made by the respondent, so I'll make it here. I've already set out in paragraph 6 the judge's sensible and uncontentious starting point, to which I would only add that a stand-back approach to the reviewing officer's decision requires also that it's read in its context, which includes the steps already taken to perform the housing duty in relation to the applicant in the case of a review, the particular grounds upon which the applicant alleges those steps have been.
What are the factual issues here that you need to read these comments in context? And I don't know yet what the failure was said to be in Mr. Hack.
It was, if one looks at page, I'm sorry, my lord, I took that too quickly. Page 128, we see from the head note that the applicant was put in hostel accommodation, although he had a physical and mental condition, and contended that the local authority had failed to take account of the public sector equality duty and succeeded before the county court.
What I don't understand is what factually was the thing they failed to have regard to. What was there about Mr. Hack's case?
Disability.
Just disability. So they didn't look at whether or not the hostel could accommodate a disabled person suitably, so they overlooked his disability or failed to take into account the need to have due regard to his
Yes.
disability.
So they failed to take account of his disabilities.
Well, pay due regard to his
Yes.
disabilities,
Yes.
But it's all to do with his disabilities and whether the hostel could accommodate somebody with those disabilities.
Yes. So if you look at paragraph 19, it identifies what element of the PSED it says was engaged, and it concerns disability and the failure to have regard to that, the public sector equality duty, the impact of disability, and the obligations under section 149. So in
And the result was that they had in fact looked at his disabilities adequately, and therefore there had been no breach of PSED.
precisely, and what this case shows, and it's right and proper that I point it out, and I will do so in the next case, is that one doesn't need to know what, contrary to what's said in, or what might be deduced from bracking, it's not necessary for the decision maker to know of the PSED, so long as in making the decision they have indeed discharged the obligations under it. So
Well, the aim is to look after people with protected characteristics. If they look after people with that protected characteristics and they thought about it, that's what they were meant to do.
well, it goes much further
I
than
know, but I'm shortening it, but that's the key thing, is to look at the needs, if you like.
it's to look at the question whether or not discrimination might need to be eliminated, and that requires a focus on disproportionate impact, and it needs to consider whether or not advance equality. But if those things are done, then the fact that the decision maker doesn't know it doesn't mean that the PSED is not complied with, perhaps unsurprisingly. And just
Sorry, I was kind of assuming that you were going to be relying on paragraph 43, which, although of course expressed by reference to the facts of the case at hand, which are completely different to our facts, is illustrative of the kind of approach that you are urging upon us.
yes,
And so Lord Justice Briggs there says that what the PSED on the facts of that case required was a recognition of the impairments, a focus on the specific aspects of the impairments that were relevant to suitability, focus on the consequences, and so on and so forth.
yes,
And that approach is endorsed by Lord Justice McComb at 63, with whom, and Lord Justice Bateson agreed with both, although Lord Justice McComb, of course, is careful to point out that that doesn't mean that you adopted a tick box approach.
I was going to take you firstly to the last sentence of paragraph 41,
Right.
and then to 43 to address precisely what your lordship has flagged. At paragraph 41, it's looking again at the question whether or not one can discharge the duty through, notwithstanding that one doesn't know, but through consideration of other matters. In HOTAC, it was vulnerability, for example. But the last sentence says, what emerges as a general principle is the sharp focus required of the decision maker upon the relevant aspects of the PSED, where it's engaged by the contextual facts about each particular case. So while it's not necessary to know, I emphasise again that the matters that are the subject of the PSED must be had, due regard must be had to them. And as your lordships just observed, an illustration of that, applicable in that case, was given under paragraph 43. So a very detailed analysis. Next question is, what in that context does the PSED as set out in section 149 require of the reviewing officer on the particular facts? A recognition that Mr. Hack suffered from a physical or mental impairment having a substantial and long-term adverse effect, etc. Focus on the specific aspects of the impairments, focus on the consequences of the impairments, both in terms of disadvantages, he might suffer in using the room by comparison without those persons without those impairments, a focus on particular needs in relation to accommodation, and a recognition of particular needs, Roman numeral 5, and so on. So a detailed analysis sufficient to discharge the obligation under section 149 to have due regard to the need to eliminate disability discrimination in that context and advance equality of opportunity. And we say we don't see anything like that in this case. We don't even see a recognition that the benefit cap disadvantages women, and therefore how that might be mitigated, the extent of it, and so on. So,
And Lord
yes,
Justice Briggs summarised those requirements in 44. It required him to apply a sharp focus upon the particular aspects of Mr. Hack's disabilities and to ask himself with rigour and with an open mind whether the particular disadvantages and needs arising from them were such that room 315 was suitable as he's got it.
precisely.
So that's it in a nutshell.
Precisely. Let me just see if I need to take you to any other paragraph on that. I don't think I do. Yes, so that's that, if I may. So yes, it can be discharged in the exercising of another function, even if it's not known about, but nevertheless there is a detailed, sharp focus required if the limbs of the duty are to be properly discharged. The respondent relies on McMahon, if I pronounce that correctly, can't find at page 281 of the bundle. This is a case on vulnerability. A person may be in priority need for the purposes of housing under the Housing Act where they're vulnerable. So, where they've got children and a number of other things, but including where they're vulnerable. And there have been a number of cases on vulnerability, and this concerned disability and a contention that the PSED was not complied with. Paragraph 18 just identifies that the starting point is HOTAC, so what matters have to be considered, and then at page 291, so we're looking at vulnerability and disability. Forgive me. So looking, please, I beg your pardon, I just lost my place there, I do beg your pardon. So page 291, we can see paragraph 41, paragraph 40, just so we can locate it, this is the review decision. 41, under the Equality Act, I confirm that I've had regard to the Equality Act for the purposes of the Act. Disability is defined, and she defines it. I acknowledge that Mr. Kiefer suffers from intermittent claudication, severe wrist pain, type 2 disability, and depression. I'm of the opinion that his depression could be regarded as a disability. So she focuses on whether or not the applicant has a relevant protected characteristic for the purposes of the duty. I'm not satisfied that he should be classed as vulnerable on the basis of the depression alone, and identifies other matters and concludes that he's not vulnerable. And then at paragraph 44, makes it clear that arid debates are to be avoided. And then at 48, makes it clear, and again this is an important matter in my submission, PSED is not a freestanding duty. It applies to the way in which a public authority exercises its functions. So that's throughout, in our case, the discharging or the performance of the duty. At each stage, each element in the exercising of those functions, the PSED must be had regard to. And then at paragraph 50, citing Lord Neuberger in Hotak, in the following paragraph, he went on to deal with the argument that in the context of an assessment of vulnerability, the PSED added nothing. That was the argument. He said, I quite accept that in many cases, a conscientious reviewing officer who was investigating and reporting on a potentially vulnerable applicant and who was unaware of the fact that the equality duty was engaged could, despite his ignorance, very often comply with the duty. However, there will undoubtedly be cases where a review which was otherwise lawful will be unlawful because it doesn't comply with the equality duty. So again, there must be a focus, a sharp focus on the elements of the duty because it applies at each stage of the exercising of a relevant function, and mere consideration, for example, of disability or vulnerability won't be enough to discharge it, we submit. And then at paragraph 67, mindful again, this is a vulnerability and disability case. Paragraph 67, the greater the overlap between the particular statutory duty, vulnerability, under consideration and the PSED, the more likely it is that in performing the statutory duty, the authority will have also complied with the PSED, even if not expressed. By the same token, the more that a particular decision to which the PSED applies is tailored to the facts of a particular case rather than being broad formulation of policy, the closer will be the connection with the PSED and the facts of a particular case. Citing Lord Neuberger, the two are complementary. In this case, I flag that because in this case, there is not that overlap. In McMahon, as in Hotak, vulnerability and disability were the subject of the suitability decision. Vulnerability had to be explored and disability in that context, and the impact of disability in that context. So it was easier for the local authority to contend successfully that they discharged the duty in the performance of their assessment on vulnerability and disability. Here, we're not in that territory. Here, we're on, is the benefit cap discriminatory? Is the policy that depends upon the benefit cap discriminatory because of its impact on women? That's not...
The benefit cap isn't discriminatory. You say the housing policy, which you say uses as a proxy, is discriminatory, but the benefit cap has been found not to be discriminatory in convention terms, and it's never, as far as we can see from the cases we've taken us to, been established that the statutory instrument is invalid because it breaches the statutory equality provision.
I beg your pardon, that was a slip of the tongue, and I think I introduced that at the outset. I am sorry. Yes, the benefit cap is not unlawful, and as I indicated when I looked at section 19, it doesn't need to be unlawful. The policy itself, dependent upon the benefit cap, is something that disadvantages women. Therefore, we say the PSED is directly engaged, and there is not an overlap in considering suitability in this case and the disadvantage caused by the policy as compared to, for example, vulnerability and disability in the case that I just looked at. As to this case then, if I can ask you please to look at the core bundle of documents. And page 169 in the first instance, which is the offer. This is the offer, and 169, it sets out that it's in the discharge of the duty, second paragraph. Paragraph 3, it describes the nature of the tenancy, and then over the page at 170, describes the consequences of not accepting it. This might be intentionally homeless, or the duty is discharged and they don't get anything else. At page 171, top of the page, first substantive sentence, this offer satisfies the council's attempt to relieve you of your homelessness by offering a private rented sector property with a 2-year tenancy. The offer of this property was also based on your family size and composition and was the only property available to you at the time of the offer. The property was also offered to you as your benefits are affected by the benefit cap. So it's imperative that you are moved to an area and accommodation with a low local housing allowance and low weekly rents.
Where the property is affordable to avoid you falling into rent arrears.
Yes, yes. And so the policy is, it's imperative that because you are subject to the benefit cap, you are moved outside of London. Gives an explanation for that.
Hold on. The policy is imperative because you're subject to the benefit cap to move you out of London.
Yes. Or to an area where there's low rent, but in reality that's out of London.
Yeah.
So the benefit cap is used as a proxy for suitability and affordability, with no other matters taken into account. And then over the page at 172, paragraph 4, numbered paragraph 4, considered suitability, satisfied the accommodation is affordable, having considered the rent and income and so on. And then 7, public sector equality duty, considered the public sector equality, in particular whether you have any protected characteristics, and if so, how this impacted on my assessment of suitability. You confirmed that your daughter has allergies, no special intervention or treatment needed, able to perform daily living activities, confirmed there were no disability or mobility issues. Therefore, I'm satisfied there's no breach of the Equality Act. I've also considered other characteristics protected by the Equality Act. I note you're a couple. Well,
is that right, or is that just a mistake? She's not. She's
not
a single parent.
She's a single parent. She's not a couple. That's right. I note that you're a couple, no she's not, with 3 dependent children. I cannot establish that you were prejudiced in any way when the property was offered to you. I'm satisfied it meets your housing need. So doesn't take account of the discriminatory impact of the benefit cap, doesn't recognise it. Certainly doesn't recognise it in relation to single parent women because it proceeds on the basis that she's part of a couple. And then just for completeness, at page 173, the final substantive paragraph, we've carefully considered your personal circumstances in line with the various relevant provisions and the Equality Act. Yep. So that's the offer made. No consideration, we say, no focus on the impact of the benefit cap on women, poverty, on women. So no consideration of the public sector equality duty and its limbs. If I can take you, please, to the supplementary bundle, show you the context for that decision, a context, I should say. And ask you, please, to look at page 100. This is the accommodation needs form, which as is plain, is the form that is completed to identify the particular needs of the applicant concerned. The date of it, just for your note, is the 30th of June. We see that from page 102. So the 30th of June, before the offer is made. And at page 101, heading duty this accommodation placement is being requested under, and then we've got the interim duty, which is the relief duty, not the final duty, but in any event, the only consideration under the needs form, and we've seen no other needs form, is for Zone C outside Zones A and B. We see that at the bottom, Zone Z, yes. So outside of London, having just above the chart, the table, having considered all the information in the system, the applicant can be placed in Zone C, outside Greater London, and none of the reasons, no reasons given. We say no reason.
That was the needs form in June. The world moved on. We had the offer that you've taken us to after that, and then we're going to get to the review decision, aren't we, which is later still.
Yes, but what in my submission this demonstrates or reinforces is that there's no real consideration given to the particular case, and less so the PSED. There is a default position. No reasons given, nothing said about why. It is just you're in C. The form is not otherwise completed. So we look at page 103. There's a pro forma form, and you'll see in the lighter text between the bullet holes, hole punches, you'll see that various alternative suggestions are made, and neither of those are completed, and the form's not completed. So it's a default, you're in Zone C, no reasons given, and we say the obvious inference to draw from that is just as we've seen in relation to the offer letter, there's an assumption that if you're on subject to the benefit cap, you're automatically Zone C. At page 94 of the supplementary bundle, so the same bundle, there is an application for a review. It's described as an appeal, but it's understood to be an application for a review by the applicant in her own name. And she describes the circumstances. I needn't go there because I'm sure that you will have had the opportunity to look at the circumstances, and she's unsurprisingly very troubled and distressed at being so far away from those she knows and loves and her support networks and so on. And she raises the benefit cap in particular, the penultimate paragraph. She's unrepresented at this stage. The process has made me feel I've been treated unfairly as regards to being on benefits with the benefit cap.
I'm sorry, where are you?
I beg your pardon. So 94,
Yes.
penultimate paragraph on page 94.
Oh, I see. Right. Yes, thank you.
Process has made me feel I've been treated unfairly as regards to benefits. And my mother even had a phone conversation with Valerie, was told that they found a property in the area of rent around 1,400. However, it's the benefit cap that affects this. So,
reading that and trying to understand it, Valerie is somebody from the local authority, and is Valerie telling her mother there is a property available, one that can accommodate the family, but it's going to cost 1,400, and are we meant to infer that that's above the benefit cap?
I'm inviting you to infer that that's above the benefit
That's
cap.
what that means then.
But the important point in my submission as well to take from this is that even at the very earliest stage, even when the claim applicant was unrepresented, she intuitively knew that the benefit cap was a problem, and she passed that on to the...
Yes, but I just wanted to understand that it's a problem because it means she can't pay the £1,400 for the property that Valerie says she's found, but the council have found a property, but it's too expensive because she can't pay it because of the benefits cap. Is that what I meant to read there?
Yes.
Yeah, okay.
Eventually, she came to be represented by Hackney Law Centre, and they put in submissions on her behalf. But shortly after that, and fuller submit, I jump over this because there's a further response, there's a further process. What happens is, before a final decision is reached, the local authority serve a minded to letter. We see that at page 31.
Well, there was responses first from the Hackney Centre,
Yes.
and then they sent the minded to letter, I think, in response to that, and then there's another long letter that comes after it. That was the sequence of
Yes. So the applicant unrepresented puts in her application for a review. She instructs Hackney Law Centre, who put in some submissions. There's then a minded to letter, which deals with the whole thing, not just the submissions by Hackney Law Centre, deals with the whole thing. Hackney Law Centre then given the opportunity to respond to the minded to letter, and then there's the final decision.
Yeah.
So the minded to letter is at page 31. At page 41,
do we need to go to the minded to letter? Because it largely is repeated in the final letter. I don't want to stop you if there's something different there, but it's the final letter that we're looking at, isn't it?
well, it's safe to identify the limited scope of the inquiry in relation to the PSED throughout.
Oh, right, okay. Do go through it.
I'm going to do it very briefly. I'm not going to take you through. Just, if I may just flag that page 41, the PSED is identified. Page 42, the duty to make adjustments is identified. That's in relation to disability. Disability again at page 43 and 44, but only disability is identified as a relevant feature for the purposes of the PSED, not sex, no regard to the impact on the PSED or the benefit cap, and then the response of the Hackney Law Centre to the minded to letter is in my submission important because it raises head on the question of discrimination, disproportionate impact, and so it was a matter that on any analysis ought to have been dealt with. So if I can take you please to page, still supplementary bundle, page 4, we've had the minded to letter. Hackney have an opportunity to make submissions in relation to that. And at page 4, so the first page, identifying whether or not, dealing in particular with temporary accommodation, paragraph 103, it's been demonstrated that you would not have been able to afford accommodation in Zone A, considering the information on file, so full stop. And then citing paragraph 107, in any event, when examining your case overall, it's reasonable for me to say that even if there were a 3-bedroom property in London or near London, it's unlikely that they would have offered it to your family unit for the reason that you're a non-working household at a time whose benefit capped and children aren't at a critical stage. So again, the benefit cap. And then complains, next paragraph down, Hackney Law Centre complained that she was never provided with temporary accommodation under the main duty, that is in performance of it, as discussed, and such accommodation was never considered as part of the process of the point of eviction, and main duty was accepted, but the main duty had not been met with any actual other accommodation, instead left to wait for eviction. So the complaint is there, you leave it to the very last minute, and then you can't find anywhere. And then over the page, dealing with the impact of the benefit cap, making it clear that it doesn't bite in relate, and I said that I would take you to this point, the benefit cap doesn't bite on temporary accommodation. Benefit cap doesn't bite in the way envisaged by the decision maker if the applicant is housed in accommodation to meet the homeless duty, temporary accommodation. For those in accommodation under the main duty, housing costs are met through housing benefit, and housing benefit is not taken into account for the purposes of the benefit cap. So that was the point I was making earlier. One's looking at mitigating or ameliorating features. Temporary accommodation, even within London and expensive, is not subject to the benefit cap. And then next paragraph down, didn't consider the opportunity of providing her with temporary accommodation. Last 2 paragraphs, as outlined above then, this is rooted in a misdirection on the benefit cap. While not exempt for the benefit cap, if the accommodation is provided to an applicant as temporary accommodation under the main duty, then any housing benefit income is disregarded for the purposes of universal credit. In effect, the applicants under the duty and in receipt of universal credit do not feel the effects of their benefit cap because housing benefit isn't included. So saying should be temporary accommodation, something should be considered. Next paragraph, putting that in context, that the benefit cap, it describes it as does indirectly discriminate, a mistake I've fallen into more than once. It means disproportionately impact. And then if I can take you please as well to page 14, same letter.
Well, whilst we're there, before we turn to the next page, at the bottom, the policy paragraph that they seem to be saying that's the policy that's applied here and gives rise to the difficulty is 314, and that is the policy that you say is the problem that's using benefit cap as a proxy, the policy that starts at 116, and is it paragraph 314 that you say is the proxy policy, or if it's not that, what paragraph is it, or is it more than one paragraph? Because you've said a number of times that the housing policy has the potential to give rise to indirect discrimination, contrary to section 19. They must have due regard to the need to avoid indirect discrimination. So I think it would be helpful if you could just confirm that what the Hackney people were saying is right and it's 314, or whether there's some other policy that is a problem.
See paragraph The current yes, so it's 116.
Yeah, the policy. That's the right policy. I've got the right one there.
You've got the right one, but additionally there is a temporary allocation policy that suffers from the same problem. So it's also, let me just give you the page number.
So first of all, it's paragraph 3.14, which is at page 120.
Yes.
That's the one that you say is the proxy policy that's giving rise to the potential indirect discrimination.
Yes. And the temporary accommodation allocations policy at 126.
Yeah, just before we get to that, I appreciate you're commendably trying to take things quickly, which I do appreciate. But just for the slower people in the
sorry,
corner,
I'm
like
sorry.
myself, I think it's particularly the last sentence that you're focusing on, isn't it, in 314? If the benefit restrictions (brackets cap) makes properties in Waltham Forest and London unaffordable, then they will not be regarded as suitable.
I've now lost the page that I'm on.
120.
120. Yes.
It's particularly that last sentence of 3.14.
Yes. Yes.
Yeah.
So precisely. And that's precisely the policy, and it's consistent with what happened in the applicant's case, we say.
And you were going on to refer to temporary accommodation. So
The temporary accommodation policy is at page 126, and it again refers to the benefit cap at paragraph 1.5.
Well, 1.1 says this policy applies to all households placed in temporary accommodation under various duties, including section 193, and I'll come back to that in a moment. So that's the starting point. This is the policy that applies to them. And then it's 1.5 you want us to look at.
1.5 refers to the benefit cap again. And I've just lost my flag. I'll come back to that, but in any event, the PRSO, the private rented sector, deals in terms, that's the offer that we were made, deals in terms with the benefit cap, makes clear that the benefit cap will be the proxy, and that, in effect, as the needs form identifies, means if you're on benefit cap, you're going into zone C.
Is this a convenient time? I don't want to take you out of your route to ask another question about temporary accommodation.
Please do, and if I can't answer it, I'll give it to my
Yes,
Julie.
better than you can get him to do it over lunch. The duty under section 193 is to secure accommodation. That's what they've got to do. Mm-hmm. And they remain under that duty until it's discharged. They can only completely fulfill their duty and completely discharge their duty if, in effect, permanent accommodation in some form is provided. The private sector rented offer or permanent accommodation under the Housing Act. If they can't do that, which is what they're supposed to be doing under the policy, then they can say, well, we haven't got it at the moment. This will be suitable in the short term or the medium term whilst we continue to work on fulfilling our duty. But it sounds to me at the moment, and you'll tell me if I've got this wrong, as if you're saying, don't fulfill your duty. Don't do that which you're supposed to do under section 193. Do something a bit short of that on a temporary basis. Why? Why shouldn't I fulfill my duties as a local authority? Because that way we can get around the benefits cap. And that doesn't seem to be what the Housing Act was meant to do.
Well, the Housing Act anticipates that suitable accommodation may not be made available immediately, even where the main duty is there. You may be in a bed and breakfast. You're a victim.
Well, if it's overnight, it often happens. It's a Friday night, you've got a mother and 3 kids. Yeah. They've got to go somewhere. It's suitable in the short term.
Well, regrettably, it can be more than overnight.
Well, yes, but as an example. But focus on the point is that the aim of the duty is to secure accommodation, and that is meant to result ultimately in an offer of permanent accommodation under Part 6 or a private sector tenancy. It's one of those two things. But it's got to be affordable. But what you seem to be saying is when they're performing their duty under Section 119, they shouldn't perform it. They should, in a way that discharges it ultimately, they should do something slightly less than full performance or performance leading to discharge. They should provide temporary accommodation. I don't know for quite how long. And the reason why you're saying don't discharge it, do a partial performance, is that you want to avoid the benefits cap. And I'm wondering if that is really what the Housing Act was set up to do.
Well, the Housing Act is to secure, the duty is to ensure that there is
Suitable
accommodation and anticipated. There is provision, in fact, Mr. Mullin may have it closer to mind than me, but there is provision as to how long the accommodation must be available for. It must be permanent, the degree of permanence.
Well, in this case, it was a 2-year offer.
2 years. Yeah. 2 years.
That's what it's got to be, yes.
Yeah.
When I say permanent,
yes. So
long term,
precisely.
either permanent
I think I said
or
permanent.
long term.
Yes.
But
So
the aim is not to have something less than that which would amount to discharge. The aim is...
But the performance of the duty,
Yeah.
during the performance of the duty,
Yeah.
one may be put in temporary accommodation.
Yes.
As I've indicated in an earlier stage of my submissions, the authorities recognise that in fact there may be circumstances where it is justified or wise to hang back from a total discharge because something might become available in due course, as here.
Yeah.
So we say there is the possibility for ameliorating the impact of a cap which disadvantages women by using temporary accommodation where the benefit cap will not impact because it will be paid through housing benefits, and wait in the hope that something comes up.
But isn't that McCauberish?
Yes.
No, it's not. It's only Macauberish if there is really no prospect, and it's given the serious impact on the women concerned, or in my applicant in particular, there is a real need to scrutinise, look around, find.
And so you would say, would you, that in the case of a single woman with children, on each and every occasion, unless there is something in Borough which is affordable within the benefit cap, that the procedure ought to be that you put that person into temporary accommodation within Borough because that is outside the benefit cap, and you wait and see for a particular period, and then you decide at the end of that period what you can do to actually discharge your duty, which may be at that stage, and I don't know how long you say that interim period is, maybe still outside Borough.
It may be nearer outside the borough, and one of the other, the earlier statutory instruments I took you to made it clear that on the location question, one is looking at distance. One can't say, well, we'll only get stuff in Newcastle.
But the effect is that you're saying that in all of these situations, temporary accommodation should be used whilst you look about yourself.
It may be, but the point is it would have to be considered in each case, having regard to the PSED. There may be cases where it isn't necessary. Maybe cases where somebody doesn't have a settled home. They've lived in Waltham Forest. The Waltham Forest is the responsible local housing authority, but they don't have roots in Waltham Forest. There could be all sorts of reasons why.
No, but we're just looking at the relatively vanilla situation of a single mother with children.
A single mother with children with roots, support networks, home in Waltham Forest. She was brought up in Waltham Forest, families there, support networks and so on. That won't be the case in every case, although I don't shy away from the fact, my lady, that it will be the position in many cases.
Absolutely, that's what we want to think about.
Yeah.
And also, what sort of length of time are you saying?
I am told by my junior, who's a housing lawyer, and Mr. Mullen will shout if I'm completely wrong, temporary housing can be years.
Yes, exactly. That's the whole point.
Yeah.
Very often it goes on, and it needn't be the same property because it's temporary. It could be Highland Park today, it could be Southwood Lawns tomorrow, and then could be moved around. And that's why I was getting back to the question of the duty. The duty is to secure accommodation, and that duty will only come to an end. They will only have performed their legal duty finally if it's permanent under Part 6 or if it's the 2-year sure tenancy. Now, what you're doing is saying, perform it, carry on doing your duty, but don't fully perform it, don't discharge it. Instead of doing what the Act has told the authority to do something which would be enough for the moment and might carry on for years and years and years. You say, well, why shouldn't they do that? They want to fulfill their duty, they've got affordable accommodation available, and they've taken the decision to offer it. But you are saying, no, don't do that. Do something less than that. You say, well, why do you not want the authority to perform the duty? And the answer is because you want to find a way around the benefit cap. Yeah. And is that a proper way of exercising the statutory powers in Section 192?
Well, first of all, the statutory powers and duties must be read with the public sector equality duty. Yeah. And that may mean that the way in which a person is ordinarily treated is modified to take account of the need to ameliorate disadvantage experienced because of a particular protected characteristic. Because I'm a woman, I experience disadvantage. You must perform that duty in a way that's in conformity with...
The duty, the PSED doesn't entitle you to an outcome. It doesn't entitle you to more money so you can get around the benefit cap. It doesn't entitle you to a different form of tenancy because it will suit you. I know you'll say you've got to have due regard to whether or not that would be better. But in a situation where the duty is to secure accommodation, which is suitable, you say you've got to go through the routine of considering the Section 149 things with a view to having not the performance of the duty, but a semi or partial performance, leaving the duty to continue. And you say that is not achieving a different outcome. You say it's performing the duty in Section 192, do you?
What we say is that a local authority must confront the disproportionate impact. It must confront the fact that what it's doing disadvantages women. It then must have due regard to the need to address those disadvantages. And there are many things that they can think about, and I'll come to some others in a moment, but one thing they can think about is, should we put this person in temporary accommodation, having regard to the need to take account, to the need to consider, have due regard to the need to advance equality. As I indicated in Bracking, it is not an outcome-focused duty. It does not require the local authority to do that. It requires the local authority to have due regard to the need to advance equality, ameliorate disadvantage, I've forgotten precisely the words, but address disadvantage, due regard to those matters. And in giving due regard to the need to address disadvantage, it should be asking itself, are there some things we can do that might mitigate the impact of this disadvantage that she experiences because she's a woman?
It's got to be in the exercise of their functions, and the function is to provide secure accommodation. And what they're supposed to do is provide Part 6 accommodation or a 2-year tenancy. And you're saying, don't do that. Do something instead of that.
No.
Because ultimately it'll be better from the woman's point of view because she'll be able to stay closer to her family.
No, what we're saying is you should have due regard to the need to mitigate the disadvantage associated with the fact that she's a woman. And those will require consideration of the measures that are available. They may include temporary accommodation because the benefit cap won't impact.
And so the temporary accommodation fix is not temporary in the sense of one is waiting for a particular time when one then goes again to consider whether there's something suitable to discharge the duty at any stage. In fact, it's a way of satisfying, you say, the PSED, which means that that temporary situation will never come to an end.
No, it may not. It may come to an end because accommodation becomes available.
But it won't, will it, in reality, because we know that in Waltham Forest, the benefit cap won't enable suitable accommodation to be provided.
Accommodation nearer than Walsall might become available. Or the local authority may say, well, we've had you in temporary accommodation 6 months, a year, near your mum, whatever it is. We've had a look round, we've done everything we can to source other accommodation, and we cannot source any other accommodation except Walsall. And therefore, we've come to the end of the road with you. And in doing this, we've focused closely on our obligations under the public sector equality duty, or they may say, we have focused on this and we've looked at temporary accommodation as an option, but even having regard to, even taking account of the need to have due regard to the equality objectives, addressing disadvantage, even taking account of that, we don't think temporary accommodation is appropriate for you.
Speaking for myself, I do wonder if the introduction of the distance factor isn't, with a very great respect, distracting from the main issue. They looked at the various options, they've got one in Walsall, they've checked the trains, and one may or may not agree with it, but they know how often they can come back and see the father, they know how often they can come back and see the grandmother. They've looked at all of that, and they've got to take a decision. This was never really, was it, a case about, well, I'll go outside London, but not Walsall, please. Make it Market Harborough or Aylesbury. And they're not saying, well, it'll be temporary, because there's a chance we'll find something closer, which means you'll be able to see your grandmother and your father a bit more. What they really want is not to go to a Zone C outside London accommodation. And in reality, you're putting people in temporary accommodation here, not to see if a more suitable property in the physical sense, or a property closer to London will become available. You're putting them in temporary accommodation for as long as it takes to avoid the benefit cap, which you point out disadvantages women in, which obviously creates a problem for your client. But that's the reality. It's not really distance, is it? It's not really another physically suitable or more suitable property will arise. This is to avoid the consequences of the benefit cap.
It's to avoid the consequences of the benefit cap, but relatedly, a Zone B. I mean, nobody's saying a Zone B would not have been better than a Zone C. If she had been in Greater London and the immediate outskirts, then plainly that was going to be better than being in Walsall.
They haven't broken the PSED duty, have they? Because of some failure to consider B rather than C. The problem is the affordable one takes them outside into the C, and what you want to do, in all honesty, is to stop the benefits cap applying to stop them being in Walthamstow with her family.
What the appellant wants to do is to have the local authority pay proper and focused regard to the equality objectives under Section 149. That may require them to think about things like this. There are other things in my submission they should think about, but we're on temporary accommodation for the moment. Yeah. They should think about things like this. It's not, in my submission, good enough to throw one's hands in the air and say, well, there is a PSED, but what can we do?
No,
the world's in a terrible state.
But why are we thinking about temporary accommodation? And I'm saying to myself, is it because there was just a chance to be somewhere closer, and that's what Hackney was saying, and that's what you were saying? And I'm wondering, is that really the case here? They weren't really saying use temporary accommodation, there might be something physically better or physically closer. It seems to me that this case, when I read the papers, unless I remember wrong, was really all about avoiding the application of the benefits cap to stop her being in Walthamstow.
No, it was about, what it was about was ensuring that she was close to her home and her networks. And as close as possible is better, perhaps, depending on what's available, than Walsall. And the point about the temporary accommodation is that it provides a breathing space, and as I've said, the cases permit that, a breathing space, and it doesn't disadvantage the council. The council can't say, well, the rent's not going to be able to be paid. What's going to happen? The temporary accommodation, you know, the landlords are going to say, we haven't paid the rent. No, the benefit cap doesn't apply. And so it provides a breathing space. It provides the opportunity to consider accommodation near, and the benefit cap, yes, doesn't apply, so it makes it a more realistic option. One of the options that can be considered, and as I've indicated, my lord, if one just says, well, this is the scheme, there is a benefit cap, there is a duty that requires you to, let's say, presumably with reasonable speed, discharge it, and there you are. There you are. We needn't even put PSED in the decision letter, or we can put it in a footnote. No application here because nothing we can do.
But Ms. Moynihan, what I was trying to get to as well was, how long is it that you say that this interim phase must operate? Is there a minimum time? You're saying that in fact the local authority ought to be looking around to see whether in fact they're going to be able to provide something closer. What are you saying about how long that temporary situation continues?
We haven't put a timeline on it, and it may be that having regard to the matters under section 149, the local authority could say no, as long as they've had due regard to the matters under section 149, or they could say, okay, we'll give it a bit of time. We're putting out a procurement exercise next week. Let's see if something comes up. Or we give it 6 months, as the case may be. This is a woman who's in desperate need. We'll give it a bit of time. So I don't put and I also don't do that, my lady, just to reiterate, to emphasise, I hope not too much, that of course it's a due regard obligation. They can think about these things and say no. But they are required to think about them. And the difficulty here has there been no consideration of any ameliorating measures, or whether they might work, how long they might be, whether there's a possibility of obtaining accommodation from other sources, because there's been no confronting of the impact on women.
Thank you. I think we better move on.
Yes. So I just showed you that the issue of the disproportionate impact had been raised in terms by the Hackney Law Centre. Just for your note, it's raised again at page 14 in terms. So it ought to, we say, have been firmly in the mind of the local authority, the decision maker. If I can take you then, please, to the decision. That's in the core bundle, going back there, and it's at page 123. And if I can ask you, please, to turn up page 133 in the first instance. And we can see, excuse me, I'm trying to get this be efficient, and I hope I'm not being less efficient. And so if we see, please, at page 133, the public sector equality duty is set out. The duty to take reasonable adjustments is set out at page 135, with disability discrimination there too. Page 136, concerned with disability, no analysis in relation to sex, although it had been referred to in terms. And then at page 139, paragraph 73, paragraph page
Well,
139.
just before you get that, you could make the point that although they set out various paragraphs of the policy, the paragraph that's been attacked, 3.14, is not set out.
Yes. Thank you. And then at paragraph 73, in your solicitor's responses to the Minded 2 letter, he's talked about the benefit cap, alleging that the council has placed continued reliance on the benefit cap as a justification for housing you out of London. I disagree with his responses, which accuses discrimination. So presumably, this is intended to refer to the allegation that there's disproportionate impact and nothing's been done. And that does not confront it in any meaningful way, nor does it identify or put into sharp focus those matters under section 149. And in my submission, it simply cannot be said that there is a discharging of a duty. And at page 163, sorry, forgive me, if I can take you just for completeness to page 155, because the Equality Act is referred to again, page 155, considers disability only and medical...
You say disability only. I think, to be fairer, one of the things that had been raised was disability.
Yes.
The youngest child in particular
Yes.
was said to have problems, and your client was said to have problems. It's not surprising that they deal extensively with disability. Your real criticism is there's nothing else in the letter.
Precisely, it doesn't deal with sex. I mean, the protected characteristic in issue here, for us, for the appeal, is sex.
Yeah.
So it does deal with disability. It doesn't matter whether it deals with it adequately or not for our purposes. Our claim is, our appeal is...
No, I understand that, but it's not fair to say, look, they've thought only about disability. They're addressing what's been said.
Oh, yes. I mean, I don't
It's
say
a little
that.
bit unfair
Yes,
to
I'm not
treat the
suggesting...
length, if you like, of the treatment of disability, because that's what they were drawn to their attention.
Yes. I'm simply taking the court to the extent of the consideration for PSED, so it's all before the court, and we see that at page 155, and then at page 163. We say they make the same mistake in relation to temporary accommodation at page 142, paragraph 142. And 143, can't afford it.
Well, 142 does say, moreover, for your information, we do our best to house all applicants in their area of choice and as close to their previous residence before they became homeless as far as it is reasonably practical. This is not always possible. The demands for housing far outweigh supply. They have no authority and no option but to source accommodation, even though it's Ireland, and this is the case with you, even though it took some time. It does look as if they spent time looking for something else, doesn't it?
Well, paragraph 143, it appears that they are dealing with the affordability question by reference to the benefit cap as well, under that same section.
You would have been able to afford accommodation in Zone A, but 142 seems to be dealing with the broader things about being closer. So anyway, so 143 you want us to look at, yeah? Well,
143, again, not being able to, it's been demonstrated you will not be able to afford accommodation in Zone 1 because you're benefit capped.
Yeah.
And that's temporary accommodation as well. It's not making any distinction between, as I read it, my lord, between temporary accommodation and permanent accommodation. You are, you're benefit capped and that's it. And the temporary accommodation policy, again, is refers, as I took you to earlier, to the benefit cap, and that issue being significant there, and we say, well, you failed to take account of the way in which temporary accommodation might be managed differently. So we say sex hasn't been confronted at all. notwithstanding it should have been there in front of them. In consequence, no mitigating measures considered. They may say, well, we've thought about this, we've thought about that, but we've decided on balance X. And as was said in Bracking, it's not for this court to undertake the exercise of whether or not appropriate weight has been given, but it is this court's does lie within the jurisdiction of this court to determine whether or not the due regard duty was met.
And when one sees paragraph 144 and having checked what accommodation was available at particular times, reference is made there to temporary accommodation that was available or not available and its suitability. So that was taken into account in that survey at least. And then for various reasons.
It's too small.
It's too small or whatever.
Well, too small is a peculiar one because these two smalls are 2 bedrooms. There's no requirement to have more than 2 bedrooms in the size of this family because, of course, there's one child's under 1.
So I think we just, for cross purposes, then looking at temporary accommodation, and you said they weren't, but a lot of the temporary accommodation they identify wouldn't be suitable for other reasons. A 1-room temporary accommodation is unlikely to be suitable for a parent and 3 children.
A 2-bedroom?
No, I said a 1-bedroom.
I beg your pardon.
2-bedroom isn't
I beg your pardon.
said to be temporary. The ones that are said to be temporary are 1-bedrooms, I think, all of them.
Well, they do, but what they then go on to say, if I can just take you to the next section, paragraph 147 at 165, they refer to a 3-bedroom, as I've indicated.
Yeah.
Seems it doesn't need a 3-bedroom, but in any event, for present purposes, in any event, when examining your case overall, it's reasonable for me to say that even if there were 3-bedroom properties available in London or near London, unlikely that they would have been offered to you for the reason that you were a non-working household at the time who was benefit capped. So they are looking at, for accommodation through the prism of the benefit cap and not asking themselves, do we need to explore further? Do we need to put in a 2-bedroom? A simple no, we're not doing anything because you're benefit capped.
No, and with children who are not at a critical stage in their studies.
Yes, yeah.
And 148, there wasn't temporary accommodation. There are 2 things. One, the temporary accommodation, and 2, it still sounds to me as if you're trying to get this authority not to consider how they fulfil their duty under 192, which is to provide accommodation, which is POSIX permanent or 2-year tenancy. And when they say it's got to be affordable, so they're talking about how do we fulfil our duty? How do we make sure we give you what we're supposed to give you under the Act? And the answer is it's got to be affordable. And if we give you what is suitable under the Act, it's not going to be affordable if it's in London. And what you would like to do, I think, but we've had this debate.
One of the things. I'm not suggesting this is the only argument, but focusing on temporary. Because
but you would like temporary accommodation, i.e. something that doesn't amount to the discharge of the duty, because it has benefits in terms of benefit caps, which fulfilling the duty is. And one of the questions that puzzles me is the authority required to do that? And your answer is, and I've got it written down, they must have due regard, so they can come back tomorrow and say, yeah, we consider that, but we are actually going to fulfil our duty, and it's not affordable. And you say they've got to say that again, because they've got to think about it.
And they've got to do it in a meaningful way, an open-minded way. Yeah. I mean, it's not enough to come back and to have of course, I know your Lordship isn't suggesting it, but they've got to give meaningful, open-minded, conscientious consideration.
We thought about not fulfilling the duty and discharging it, but just doing a series of temporary accommodations, and we know that will help people like your client who are women, because it'll avoid the cap. But no, we're going to do what the law says, which is to provide permanent accommodation. And we've had due regard to the need of the thing, but it doesn't trump the duty. And you would say that would be all right, but you say they haven't done it yet.
Well, I would then say, have you considered these other things? but we've got to
Well,
that
you're gonna
stage
get
yet.
there,
Because,
So you only mentioned three things in your skeleton: Part 6 accommodation, temporary accommodation, and extra cash.
extra cash, and when I took you to DA,
Yeah,
to
the DHP.
to the DHP, which
Yeah.
was regarded by the Supreme Court as a key mitigating matter.
In assessing the compatibility of the benefits cap with the convention, yes.
Yes. So, so we say something that's in particular had regard to in justifying the benefit cap as a generality, not something considered here for the purposes of topping up income and subsidising housing.
Can you help me? I haven't understood what topping up income would be available, because I mean, Waltham Forest, so far as we know, doesn't have something akin to the DHP, does it?
Yeah, they're administered by local authorities. So they're paid by central government, but administered by local authorities. So there's a
But would DHP be available to someone in the circumstances of your client?
yes.
Right. Okay.
In fact, I understand, although I haven't quite worked out why, but I understand at some point in the past she's actually received DHP, but not so far as is relevant here, as I understand it. But yes, so...
But I'm sorry, that the reason why I kind of made the opposite assumption, I'm grateful to you for correcting me, but doesn't that work against you? Because then your client's remedy is to say, give me some DHP.
Yes, and she has...
So it would be perfectly consistent with the PSED, as I understand your case, for the local authorities to say one of the mitigating factors is the availability of DHP, and it's for the applicant to apply for it.
Or it's for the pursuant to the PSED, it's for the local authority to consider it and to have regard to it. PSED...
But they can't be required actually to pay it, particularly to someone who hasn't applied for it.
No, they can't, but they can say, we've considered your application and the impact of the benefit cap on you. We are looking at mitigating measures. We've identified these, and one of them is, we think we can find you local accommodation if you apply for the DHP. It's not good enough simply to say, no, your Zone C, on your very first form, your accommodation needs form, we're not going any further, your Zone C. They could say there's disproportionate impact on women. I think we can do something here. Now, these are all matters to be had regard to. We don't say, and I appreciate that we must explore the reality of them. I understand why we're exploring temporary accommodation. They've got to be real possibilities rather than utterly fanciful. But nevertheless, there has to be some sharp focus, conscientious, open-minded consideration. And it requires somebody to sit down and say, there is sex discrimination. Sorry.
Discrimination, there's discriminatory impact on women, yes.
There is disproportionate impact. Yeah. In fact, discrimination is used a bit flippantly sometimes I think Lord Newberger uses it once when he means disproportionate impact. So I hope I'll be forgiven for falling within his camp. It's just a pure oversight, slip of the tongue. But disproportionate impact, have to confront the fact that there's disproportionate impact and have regard. And those are positive, they require positive consideration. So we have also said that Part 6 housing stock was another matter that could be considered. Just if I may, I've taken myself slightly out of turn. Will you just give me 1 minute, please? I don't think I'll take any more than that. So Part 6 housing stock, if I can ask you please to look at the authorities bundle at page 149. I am very close, subject to your ladyship's and your lordship's questions, very close to the end. Elkundi, and this was a case where the applicants were contending that they should have waited around a bit for something to come up.
And the head note says that the duty is an immediate, non-deferrable, unqualified duty to secure suitable accommodation.
Yes, it is, but it also duty to secure is made available within a reasonable period of time, and it would depend upon a number of factors: nature of the length of time that they've been in the accommodation, needs, lack of alternative accommodation, and so on. So there's no, and as I've indicated in my submission, given the authorities I've already identified, there's nothing preventing, in the performance of a duty, identifying temporary accommodation. This is just on the question of Part 6 accommodation. So as your ladyship and your lordship probably know, Part 7 of the Act deals with homelessness, Part 6 deals with permanent local authority or social housing, where you'll get a secure tenancy. It's the gold standard. Secure local authority or social housing. And if we can look, please, at page 199. This was not a PSED case, so we say a fortiori. One issue that Croydon needed to address was whether there were suitable properties available to Croydon that it could use for Part 7 without being offered a secure tenancy. You don't want to put somebody in Part 6 accommodation and they jump the queue.
This was actually about the criteria for granting mandatory injunctions when they were failing to comply with their duty.
Yes.
And Croydon said, oh, there's nothing we can do, it's too complicated. And the court was saying here, well, there's one thing you can do. You can't make a permanent offer of Part 6, but you might be able to use Part 6 at least for a short time.
Precisely.
But in your case, if you use Part 6 accommodation or a secure tenancy, you wouldn't be able to afford it.
No.
You've got to use 1 Part 6 accommodation, and 2, you've got to say, but we're not going to give you the secure tenancy, even though Part 6 is intended to lead to a secure tenancy. We're going to give it to you for a short period on a temporary, non-secure.
Precisely. We're not suggesting...
So you can avoid the cap.
We're not suggesting that one can queue jump by saying you've been on the Part 6 housing list for 2 years, but we're going to put this person in there instead and give them a secure tenancy. What was anticipated here was that there would be Part 6 accommodation, could be Part 6 accommodation provided without a secure tenancy. So, pursuant to a temporary arrangement.
The accommodation was earmarked for Part 6, but it would not be used for Part 6, it would be used for Part 7.
Precisely.
And what you want to do is possibly the same. You want to take a property that's earmarked for Part 6 and use it for Part 7. But you want to do it for a temporary basis, because the one thing you want to avoid is having anything that smacks of a secure tenancy, because, as I understand what you said, you're capped by the benefits. You're getting the physical properties on your Part 6 list, but whatever legal arrangements are there for you to occupy, you don't want it to be a non-temporary permanent thing, because the benefits cap would hit. Or have I misunderstood?
We don't want a secure... Well, no, absolutely.
Yeah.
My client would love every person on the planet would love a secure
You know what I mean,
authority.
because you pay the, everybody would want it. But that's a silly distraction. The point is, she doesn't... If she has a secure tenancy,
yes,
the benefits cap will apply, and she can't afford it.
Subject to DHPs.
It's subject to DHP, yeah.
So, I mean, the point is there are a number of ways that a local authority could look at the problem if it put it into sharp focus.
Well, it's the same thing, although it's Part 6 or something else. The point is you want a legal occupation of the property and an arrangement which is one that doesn't attract the cap. And the way to do that is by making it for a temporary period rather than a secure tenancy. That's what you're doing, whether it's Part 6 or anything else. The key is don't make it anything more than temporary.
No, there were two things. Make it temporary, so you can avoid the benefit cap, and or make it permanent in B, A or B by topping up with DA.
Oh, no, I understand that. Yes, that's a separate thing. We're talking here about what you're doing.
No, absolutely.
Make any accommodation that you provide subject to temporary things, or alternatively, if you are going to discharge your duty and provide either a Part 6 permanent thing or the private state offer, you've got to top it up.
Yeah, and but the point is, nothing was considered because the impact on women was not confronted. So nobody sat there and said, "Yes, sorry,
we got that."
Emphasis can be overstated. I know. I beg your pardon. Enthusiasm.
Could you just explain to me whether the authority would be able to use DHPs if they place someone in Zone B? Zone B being, I imagine, the one closest to the borough, but outside borough. Could a borough or a local housing authority use its DHP funding to fund somebody outside the borough? I just wonder whether DHP would only apply in Zone A.
I'm told yes, but I don't know the answer. So I will just to be sure it's not an I don't mean any disrespect. I will check over lunch. Check over lunch so that I've got a proper answer rather than just a. I've got another note, but I'll check that over lunch because I don't want to.
Thank you very much.
It's just then. I've indicated that we're not concerned without any disrespect. We're not concerned with the judge's decision below because we're concerned with the review decision. So I'm not going to trouble you with it. But may I just? I think I've probably made the observation well enough, but. One matter the judge does address is the question whether or not, if the benefit cap itself is not generally unlawful, could it fall within Section 19 of the Equality Act and indirect discrimination? We say yes.
Yes, you dealt with that, I think.
Yeah, I dealt with that when I made the submissions. I think that's everything. May I just take a moment to ask my... Unless I can assist you with anything else at the moment.
Thank you very much indeed.
My lady.
Mr. Mullin.
I'm very grateful indeed to my learned friend and indeed the appellant in this court, as they do below, has the burden of doing all the heavy lifting in terms of setting out the background. So I'm very grateful to my learned friend for doing that. In the 15 minutes or so before lunch, there is, not where I was planning to start, but quite a nuggety point that might fit nicely into that time. And it's this, and again, I'm afraid it's going to rely on an authority that's cited in our skeletons, but we don't have in the bundle that I will have provided over the lunchtime adjournment. And it's this. It seems to me the way that the case has been put powerfully by my learned friend is that there is an instance of indirect discrimination, and the indirect discrimination flows from the council's housing policy. Now, it's right that in my learned friend's skeleton and in my skeleton that the case of Adesotu is relied upon by me to say that you can't bring a substantive Equalities Act challenge on a 204 appeal. So Adesotu, in short, was a case in this court that was an appeal from His Honour Judge Luber, King's Counsel. And His Honour Judge Luber had struck out a ground of appeal in that case below, which read as follows: the respondent breached Section 19 of the Equality Act 2010 by applying provisions, criteria or practices that are discriminatory in relation to the appellant's disability which cannot be justified. Policies, criteria or practice are operating short and flexible time limit which an applicant may accept or refuse an offer of accommodation. not permitting an applicant time in which to take professional advice, treating an equivocal acceptance of accommodation as a refusal of accommodation, and treating a failure to immediately occupy accommodation as a refusal of that accommodation. So that ground of appeal, which alleged indirect discrimination in those terms, was found to be outside of the county court's jurisdiction on the 204.
And Ms. Webb-Harnden explicitly accepted that. She explicitly accepted that
Yes.
she couldn't bring such a claim
And that-
in these circumstances.
That's right, but it seems to me it rather circumvents that ruling if you can say, you can still make all of those same points and say the local authority is indirectly discriminating, despite there being no finding, and part of my submissions probably come after lunch, is why I say, in fact, this idea that there's a proxy or a PCP, or that it's the PCP that causes the disadvantage is not right. But I don't think I need to go that far, because it can't be right that you can use the PSED to say unambiguously there is indirect discrimination when that isn't accepted.
Well, you've got two problems with that. Is a duty to have due regard to the need to avoid discrimination.
Yes.
And here it's a bit more grey because it may just be potential discrimination, because if the housing policy is as Ms. Monaghan describes it,
Yeah.
It may have direct discrimination, and what's maybe justified to have a benefits cap. Is it justifiable to have a housing policy? But the other problem you've got actually is the other limb of the public sector equality duty, advancing equality.
Yes.
And Ms. Monaghan says you're not advancing equality because there is likely to be a disproportionate impact if that's what the housing policy says.
Yes, and so to respond to all of that in part by part. So the first limb of the PSED is that have due regard to the need to eliminate unlawful discrimination or other conduct prohibited by the Act. So it's discrimination as prohibited by the Act. It's not potential discrimination prohibited by the Act. There would need, it seems to me, bearing in mind, again, I think it's agreed that on these sorts of appeals, the burden of proving an error of law is upon the appellant. If they are to say that we have failed to have regard to some indirect discrimination, it seems to me they would need to prove that the indirect discrimination exists.
You'd have to challenge the policy.
Yes, but just the fact that there's a policy on its face doesn't mean that there's indirect discrimination, because, for example, the policy, and I think again we're agreed, and it comes from Brannis Hale's dictum in Essex, is that there has to be, for indirect discrimination, while there doesn't have to be a causal link between for indirect discrimination, there has to be a causal link between the PCP and the disadvantage. So the disadvantage that's being talked about here is ultimately having less money, because that's what the benefit cap does. It gives a certain class of people less money than others, and women are disproportionately impacted.
Sorry to interrupt you.
I'm so sorry.
I'm struggling to understand
Yep.
relevance at this point at the moment, because I appreciate you've got all kinds of other answers
Yes.
to the appeal. But as far as this particular point is concerned, Ms. Monaghan didn't rely just upon section 1491A. She also relied upon 1491B,
No.
which is advancing equality of opportunity between persons who share a relevant protected characteristic of persons who do not. And the protected characteristic she's relying upon here is sex. And so the argument is that the local authority has to have due regard to the need to advance equality of opportunity between people who are female and, in particular, those who are lone parents, who are disproportionately female, and those who are not. And the argument is that in the circumstances of this case, that requires the local authority to face up to that situation and give it proper scrutiny, and then see what needs to be done, or at least think about what might be done to address it. That's the argument.
Yes.
But why is it an answer to that to say, but you can't bring a claim for indirect discrimination under the Equality Act, when that's not what they're trying to do?
Well, it is an answer in my... If I were to by virtue of this submission, cut down the potential breaches of section 149 to a breach of B, the second limb, that is 50% of the limbs that are relied on cut out.
Okay.
So it does rather well in my respectful submission. But the other point is that the ground of appeal as it's drafted is what we fail to consider according to the ground of appeal is the discriminatory impact of moving the appellant and or single parent female households out of borough due to being affected by the benefit cap. So it assumes discriminatory, and it must mean indirectly. The ground appeal assumes indirect discrimination, and that we are the ones responsible for it. So if it were the indirect discrimination caused by the benefit cap, so that's already been found by the Supreme Court to have this disproportionate impact. But if the case is, as I think it is, and it must be, that we are indirectly discriminating, because that's what the ground of appeal says, and because the first limb of the PSED is relied on, then that would require a whole series of factual findings about the effect of the PCP, whether it is a PCP, and what the impact of it is, and whether it causes the disadvantage. And as I said, all of that is inherently unsuitable for the same reasons as was found in Adissocium. As I say, I'll provide that. But to be able to say, but I can just do all of that, all of the same thing that is prohibited by Adissocium by casting the veil of the PSED over it, it seems to me would be wrong as a matter of principle. But
That's quite an interesting point. But over the lunch hour, I'm thinking about all those cases which were brought alleging breach of the PSED, and I haven't gone back to check, was it direct discrimination which was admitted, the policy only applied to men or only to particular ethnic groups? Are there cases where there was no established breach of Section 19, but the possibility that it might affect women or ethnic groups indirectly was enough for 1491A? Or can you only have 1491A when you have first established that the policy is in fact discriminatory?
Well, my learned friends deferred a little twice to her junior, who's a housing lawyer, and to me as a housing lawyer, and I'll probably take the opportunity to defer to her as a discrimination specialist. Certainly in the certainly in the context of Housing Act appeals that involve the PSED, to my knowledge, there isn't such a comparison to draw. But I wonder if that might be a convenient point to leave things, save for. I should say, because I know my learned friend said it's not in dispute, but it is in dispute. We say that temporary accommodation is automatically exempt from the benefit cap. That's not our understanding, and I think we'd want chapter on verse in terms of the regulations as to why that is.
Say that again, I missed that.
So part of my learned friend's argument is that temporary accommodation would have been better. I echo much of what the courts have observed in relation to that submission anyway, but a part of it is temporary accommodation would be better because it's not subject to the benefit cap in the same way as PRSO is, and as we understand it, that's not right. I think it's right in respect of certain types of hostel and sheltered accommodation, but I have asked those that instruct me to go away and give me chapter and verse, but we're not under the impression that it bites in quite that way. And in the review,
if you had a 3-bedroom flat which you made permanent, the cap wouldn't apply. If you had a 3-bedroom flat, but you said it's not a secure tenancy, it's year by year and can be terminated and so on.
Yes, it doesn't work.
It still applies to the cap. It doesn't not apply.
We think even if we put her in temporary accommodation, so not a PRSO, but for example, temporary accommodation that was provided either by us or by another private provider, but that it wasn't a PRSO that brings the duty to an end, it was just for the performance of that duty, that the benefit cap would still apply in those circumstances.
That's quite important.
It is, and we will try and get to the bottom of that, but it's not spelt out, certainly by reference to regulations, either in the review representations or in the grounds or in anything in this appeal yet why that's the case. So we will try and, I know my junior's been furiously trying to give me chapter and verse on it, as have those that instruct me, but hopefully we'll have an agreed position over lunch.
Thank you very much indeed then. 2:00.